Good evening, everyone. On behalf of Livelaw Academy, I, Rohit Rohilla, welcome you for today's session that is going to be about the questions that were being asked from family law in Delhi Judicial Services examination of 2023. However, this session is Judicial Services examination of 2023. However, this session is not only about examining the question paper, analyzing the kind of question that was asked, and solving it together. This session is also be going. It is also be about the tips and tricks that can work well for a candidate while attempting or while tackling problem-based questions after highlighting definitely the challenges that are being faced by a candidate. Before beginning, let me just point out one thing that if in case you have any doubt whatsoever, you can type your doubt in the comment box and all the doubts can be taken towards the end of the session, right? So on that note, like I said, that this class is not only going to be about solving the question from family law. In 2023, Delhi Judicial Services, in its civil law one paper, it asked the question from Hindu Succession Act. So we'll be taking up that question. But before going to it, let me just address few challenges, and then I'll also discuss some tips and tricks to tackle such problem-based questions. Right. So talking about the challenges first, tackling a problem-based question in the judicial services examination can be very challenging for various reasons. The first and foremost reason to is with respect to the requirement of separating relevant information from irrelevant details. Secondly, the problem-based questions are not only about testing theoretical knowledge of the candidate. It is also about applying that theoretical knowledge to the practical situations. And this particular thing can be challenging, especially for those candidates who have not practiced the answer writing. Thirdly, there is this issue of time management. Problem-based questions, they require you to analyze and then write answers to a practical situation in a very limited time frame. And this limited time frame can be very stressful at times. Lastly, there is this non-clarity in terms of the assessment criteria that will be in place while the examiner will be analyzing your answer, right? It points out to the intention of the legislature, of the examiner, as to what does he or she require from you in a good answer, in terms of a good answer, right? And figuring out this intention can be as mysterious as ordering a food from a menu which is in foreign language, where somebody who places the order might think that he has ordered a sandwich, but finally when the dish it arrives at the table, to the utter surprise, the person then comes to know that actually it was fish that he has ordered. And it can be as mysterious as a novel based on detective, from which some of the pages are missing, right? So this particular thing, it will stay with the candidates, right? You can never be able to figure out what exactly the examiner requires from you, and even if one is able to do that, it will be a very tough task, it will be a very difficult thing to do. Now, having highlighted these challenges, we must realize that there is no straitjacket formula that is of universal application, which can be applied directly and get problem-based questions. However, there are certain tips from my side which will help you in addressing these challenges to a certain extent. So, moving further, I have listed down some steps for you where you can minimize the difficulties and uncertainties that I just highlighted before you. If you implement these steps while tackling the problem based questions, um, definitely it increases your chances to get a better score than the others. The first step in this process, it requires you to read the question carefully. And if it is necessary, and if the time permits you to do so, you must read the question more than once, right? Twice or thrice. Doing this exercise right at the very beginning will make you understand the problem very clearly, and it will also, and identifying the correct issues makes your job comparatively less difficult, right? So reading of the question is is very important. Read it very carefully. Next thing, after reading the question, you should identify the provisions or the principles or the doctrines that are applicable to the given situation. Um, Once you make such a determination, once you determine which provision is relevant, which principle is applicable, which doctrine should be highlighted in this particular situation, right? Once you do that, then you must make a sketch, a brief outline in your mind as to what is going to be the overall outlook of your answer. And for this purpose, further you can utilize something that I call ILAC method. Now, ILAC, it means issue, law, application, and conclusion method. In order to give a logical structure to the answer, you can follow this ILAC method, and you can answer the question in the same order. You can start with the issue, then highlight the law, the principles, and the doctrines involved. You can then apply that law, principle, or doctrine, whatever may be the case, to the factual situation, factual matrix given in the question paper, and finally, you must conclude with a concrete answer. In the form of, it can be in the form of determining the liability, it can be in the form of allowing or rejecting an application, it can be anything. So it must end with the conclusion. Keeping your answers open ended will not fetch you more marks, right? So this ensures that this ILAC method ensures that there is coherency in the overall structure of your answer. Next, you must use clear and direct language while attempting problem based questions. And it stands true for the other questions that are much simpler in nature, which are direct in nature. You must implement this principle while getting any kind of answer, um, because a temptation that generally arises while writing law, right, while answering, it is the temptation to behave like honorable judges of the Supreme Court and the high courts, right? If you succumb to such a temptation, then definitely the language that you will be using will not be as impactful as it requires to be in terms of the answer. It will unnecessarily complicate the overall answer, and the same thing will be reflected in your marks, right? So avoid this temptation. The answer might look very beautiful to you, might appear very beautiful to you in terms of the things it contains, right? But that is not the requirement of these examinations. You must read and prepare, right? But while writing, you must be as clear as and as direct as possible, right? I'm not demotivating you to read judgments and improve further on your language, legal or otherwise. You must do it. Everybody should do it, and it is a continuous process. It should never stop, right? But the answers, they demand a clear and direct language from you, right? So don't succumb to this temptation. Next, you must keep track of the time. You must allot specific time period for each question, especially when attempting papers in states like Haryana and Delhi, where they ask very long problem-based questions, where you need to attempt sometimes more than 10 questions in 3 hours. Um, then keeping if you lose track of the time, then definitely there will be some questions left unattempted. That takes you out of the list. I will be as blunt as possible with you, right? And I think I can afford to do that. It is for your own benefit. If you lose track of your time, definitely there will be some questions that will go unattempted, right? So allot this time to for each question. Let's say that for a particular problem-based question you have allotted 7 minutes, and while you were following this method ILAC, and you were at the application of law stage, right? You have identified the issues, you have clearly laid down the provisions for the examiner that this provision will be applicable to this particular issue. Then you are at the you are uh, 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 it is 7 minutes, right? It is cross 7. Must conclude the application part and just write 2 3 lines and just end your answer. It will not be conclusionless. At the same time, it will not hamper the other questions, the quality of other answers that you will be writing for other questions, right? So through these steps, by following these steps, you can minimize the difficulties and uncertainties that we just highlighted. Now, with this, I come to the question that I was talking about. It was asked in 2023 Delhi Judicial Services in Civil Law 1 paper. Civil Law 1 paper, it comprises of 200 marks and contains some of the important areas of law, including law of contract, specific relief act, Hindu law, Muslim law. Then it also contains subjects like Delhi rent control, DMC, NDMC, and one simply cannot ignore civil law 1, right? If you ignore it, then definitely you'll be moving each with each ignorance, you will be moving one step away from the final selection, right? So this was question number 6 in 2023 civil law 1 paper. Let's read the question very carefully. As I have highlighted, the first step, it involves reading the question very carefully. Let's examine the question and let's cull out the relevant information out of it, right? It says that a Hindu by religion owns a house in Delhi. So the property in question is a house in Delhi, purchased from his self-earned income. Now, property purchased from a self-earned income, this particular fact, it tells you about the nature of the property, right? Through this line, one can figure out that the property, that the house in question, it is the private property of A, right? Let's see whether it continues to be private property of A or not. That is a different issue, right? अभी तक ये लग रहा है कि ये private property है A की, where he was residing with his wife and son. In the year 2008, A dies intestate, means, which means A has not made any kind of will that can be enforced after his death, right? He died intestate. And he left behind a wife, B, and the son, C, and a married daughter, namely D. Right? So he had and the wife is also was also living. She was alive at the time of A's death in the year 2008. One another fact is also given here. Mother of A had predeceased him. Right? Mother of A had predeceased him. Then B and C, that is the wife and A's son, along with wife and children of A's son, that is, children of C, continued living in the house. After his death, they continued to live in the house. The wife, the son, and wife and children of the son. Right? All these people were continuously living after his death in the same house. Now B dies, that is wife of A. B dies in the year 2010 after 2 years of A's death. She also dies, but this time we have a will. So wife has made a will, and under that will, she has mentioned that all her assets must go to C. C is the son. तो सारे assets उनके will के हिसाब से किसको चले जाने चाहिए? C को चले जाने चाहिए. Now, after this also, C continued to reside in the house with his wife and two sons, namely E and F. Now, details of the children of A's son's son are also given. They are E and F. Both of them are sons, right? So C in the year 2020 now decides to sell the house. F, who is one of the sons of C, files a suit for partition of the house. Now, partition can be only of the ancestral property, not the private or personal property. So, F is claiming the partition. Naturally, he will also be claiming that the nature of the property is ancestral property. It is also mentioned here that claiming that the said house is ancestral, and if the house is ancestral, then naturally there will be co-parcenary interest created in favor of everybody. And he also
Hi everyone, there's a little technical glitch. We'll just be back online in 2 minutes.
I think I'm back online.
Yes, sir. Yes, sir. You're back.
Okay. So I think the question was covered till the time we got disconnected.
Yes, sir. Maybe we can start just a little further. But yeah.
Okay. So I was reading out the question and um, highlighting the important facts that are going to be important in order to solve this question, in order to identify the issues. So the chart will look something like this, that A, who is the prepositus in this case, there was mother of A also, but she predeceased him, right? A is the prepositus. Now, he died in the year 2008, leaving behind a wife and son and daughter. The son and daughter, they are mentioned as C and D. The daughter is married. C, the wife is mentioned as B. Now, upon his death in the year 2008, the wife, the son, and son along with his children, that is E and F, both of them are also sons. E and F, they continue to live in the same house, which was the private property of A, the propositors, right? Afterwards, the question says in the 2010, that is 2 years after the death of A, the wife of A, that is B, also dies. But she has left a will in favor of C. All of the property, all of her private property, it will go to C as per the will. That is her son, right? Now, the issue that arises is when C tries to sell this house, he is a sort of, he is being stopped by his own son, F. F claims that the property in question is an ancestral property. Then there will be co-passory interest, and C cannot just like that alienate the property in favor of a third party, right? Now the examiner wants you to decide share of everybody. The examiner asks you that if B and not A was the original owner of the house, that is, one scenario is where the house belonged to A, the other scenario that you need to discuss is what if the house, right? So two scenarios have to be discussed. But before venturing into each scenario, we'll be discussing each scenario in details, right? But before venturing into them, we must realize that there is one fundamental issue which needs to be addressed first. And that issue is with respect to the nature of the property itself, right? Nature of the house, whether it is ancestral or private. And the question starts with the fact that A purchased the house with his own self-earned income, which makes the house to be a private property. But whether the same has continued to be private after his death in the year 2008 and after the death of the wife in the year 2010, whether it continues to be the private property, that is the issue. F claims that it has become ancestral, and C is acting under the belief that it is a private property. So let's first address this issue, then only we will be able to divide the property in terms of shares for everybody. So everything in this question depends on one fundamental issue: what is the nature of the property, whether it is private or ancestral. And without determining the nature of the property, nobody will be in a position to determine the shares, which is the actual demand of the question, right? Now, talking about the nature of the property, whether it is separate or ancestral, right? We must realize that it is a settled position in law that law will not move with the presumption that property uh, is a joint family property or is an ancestral property unless there is a nucleus available, and that nucleus is being utilized to fund everything, to purchase a property, to maintain the property, to maintain other expenses related to the property and the family members, right? Unless there is a nucleus present, the law cannot presume that a particular property is a joint family property. This is a settled position of law. Um, Further, the burden of proof will be on the person who alleges or who asserts that the property is a joint family property or ancestral property. That burden has to be discharged through evidences, right? Simply making assertions will not do the job, right? So, as I've said, that there is no presumption. The property cannot be presumed to be a joint family property. And existence of joint family or joint family members enjoying the property does not take you to the conclusion that property is a joint family properties. Remember, mind you, that the facts of this question also tells you that after the death of A, the property was actually um, enjoyed by all the members of the family, right? Including the son, the wife, and the children of the son. Right? All of them were using the property. All of them were residing. They continue to reside in the same house, right? But at the same time, this existence of joint family relationship or joint family members enjoying the same property simply cannot label the property to be joint family property, right? As I have said, that burden of proof, the BOP stands here for burden of proof. Burden of proof rests upon the person who asserts that any particular item of the property is joint. And the same observation was made by the Honorable Supreme Court in the year 2003 in the case of D.S. Lakshmaya versus L. Bala Subramaniam, right? It says that the legal principle thereof, after discussing the law relating to joint family property, it says that, I think it was para 18, you can check it. In para 18 of the judgment, it is mentioned that it is observed that the legal principle, therefore, is that there is no presumption of property being joint family property only on account of existence of joint Hindu family. The one who asserts has to prove that the property is a joint family property. Now, the word prove here indicates that the person concerned who is asserting that the property is a joint family property, he needs to prove it through the evidence, right? Proof is always the subject matter of evidence. In the absence of evidence, we cannot say a particular thing is proved, disproved, or not prove, that the definitions that are given in BSA and Indian Evidence Act, right? So basically, the proof has to be there, and proof cannot be in the absence of evidences, right? Now, coming to the present case, as we have seen that F, that is son of C, A's son's son, he has simply made an assertion that the property is a joint family property. He has not supplied any concrete evidence that can point out that, or that can help the court to reach at the conclusion that it is in fact joint family property. So assertion is not supported by concrete evidence in this case. So when we apply this law laid down by Supreme Court in 2003 to the present factual metrics, we find that F's assertion, it holds no ground whatsoever. It cannot be said that F has discharged his burden of proving that the property is a joint family property, because there is no concrete evidence apart from an assertion, a simple assertion made by F. So the fundamental issue on which everything depends, right? That issue will have to be decided, not in favor of F, right? The property has to be treated as a separate property, and since it has to be treated as a separate property, any devolution of this property will have to follow the rules related to either the testamentary or non-testamentary succession, as the case may be. Because once a property is labeled as private property, I'm using PP for private property, right? The private property can devolve in two ways until unless it becomes a part of joint family property, right? It will devolve in either of these two ways. Either there will be a testamentary succession, that is through will, या तो वो will के थ्रू जाएंगी प्रॉपर्टीज आगे फर्दर, right? Or in the absence of will, there will be non-testamentary succession. I'm using NTS for non-testamentary succession. Now, once the property is labeled as private property, as in this case, we have to see whether we need to apply non-testamentary succession rules as given in HSA. HSA provides, Hindu Succession Act 1956, it provides detailed rules for succession in case of property related to males as well as females, right? So if there is a case of non-testamentary succession, then HSA has to be followed. Otherwise, the property will devolve through will to testamentary succession. Now we have to see how which principle is to be applied. Now coming back to the facts. Facts are clear. Facts are clear that when A died in 2008, let me just change my pen, the color of my pen, it will be more clear. When he died in 2008, there was no will. He died intestate. So naturally, in the year 2008, the house will devolve because it is a private property, right? The house will devolve as per the law laid down in Hindu Succession Act, right? And since the property it belonged to a male member, right? A was the male, then the provisions of Hindu Succession Act, sections 8 to 13, they become relevant for our consideration, and these provisions have to be read along with the schedule. Now we are transitioning into the first scenario where house is the private property of A and he died intestate, right? Where he died intestate. So let's quickly examine these sections first and then we'll come to the facts again. As I said that in case of males, non-testamentary succession has to be seen from the point of view of sections 8, 9, 10, 11, 8 to 13. They have to be taken into consideration along with the schedule. So let's see what do they actually prescribe. Section 8 actually provides you the classes of heirs in cases of males. It simply says that there are total four classes of heirs in case of males. Class 1 heirs and class 2 heirs, they are mentioned in the schedule, and that's why reading schedule along with these sections, they it becomes very, very important. And thirdly, we have agnates, and lastly we have the when there are no agnates, we have cognates. These are four classes of heirs prescribed by section number 8 in case of succession when the property, the private property of a male is to succeed, right? We need to bear in mind that there are four classes of heirs. Now section 9 says that among heirs specified in the schedule, now it is talking about class 1 and class 2 heirs. Class 1 shall take simultaneously and to the exclusion of other heirs, which means preferential right is created in favor of class 1 heirs. If anybody from class 1 is present, the property will not devolve upon the other classes of heirs, that is class 2 agnates or cognates, right? And the people mentioned in class 1, they will take the property simultaneously, which means that though people mentioned in class 1, they have a preferential right, right? But among themselves, they are to be treated equally. There is no preferential treatment, right? Let's quickly look at the schedule. Then uh, the section 8 and 9, they will make more sense to us. See, schedule. Class 1 and class 2, it provides classification of class 1 and class 2, right? So if anybody is present from class 1, this is as per section 9. If anybody is present in class 1, then the people in class 2 will not be considered. Once you exhaust class 1, then only class 2 comes into picture, right? So class 1 contains people like son, daughter, widow of the propositors, that is wife, right? Mother, and then son of predeceased son, so on and so forth, right? We need not go for the purpose of this class. We need not go into the much details of these classifications, but this is just to appreciate what section 8 and 9 they actually prescribe. Section 8 provides you the classes of heirs, and then section 9 tells you how the property will devolve among heirs. It says that those in class 1 will have a preferential treatment. So you will not consider other classes of heirs until and unless you exhaust everybody from class 1, right? And then it also prescribes that that class 1 heirs will take the property simultaneously, which means that if more than one people are there in class 1, they are present as class 1 heirs, then they will take the property of the propositors simultaneously. They will have the equal shares. Let's say there are two people from class 1, right? So they will take the property half each, 1 by 2 and 1 by 2 each, right? That is what is the meaning of section 8 and 9 when they are read together along with the schedule. Then section 9 further provides principles regarding class 2. It says that class 2, those in the first entry class 2 shall be preferred to those in the second entry, and those in second entry shall be preferred to those in the third entry, and so on in succession. So what it means actually, in class 2, these total 9 categories are provided, right? So here there is internal preferential treatment also, right, which was not present in class 1. So if father is present, you will not consider other class 2 heirs in his presence. If father is not there, then only you will move on to the second category. And if anybody in the second category is present, you will not consider the rest of the heirs mentioned in other categories, right? So you will have to exhaust class 1 heirs first. Then let's say if the property has to devolve in category 5 of class 2 heirs, right? Then class 1 heirs have to be exhausted. Then after that, all the first 4 categories of class 2, they are also required to be exhausted, because class 2 heirs, they do not take the property simultaneously. They take the property category wise, right? Right. So please keep in mind this point of difference between class 1 and class 2 heirs that are mentioned in the schedule, right? Then section 10 tells you the rules of distribution. We have prescribed who will get the property. Now, what share will be given to them? How the distribution has to take place? Whether it has to take place per capita or it has to take place per stripes, right? There are 4 rules in section number 10 in case of class 1 heirs, right? Class 1 heirs. Class 1 heirs के लिए हम देख लेते हैं. And I think just rule 1 and rule 2 will be sufficient for answering today's question. So it says that the property of an intestate shall be divided among the heirs in class 1 of the schedule in accordance to the following rules. Rule 1 says that the intestate's widow, in our case, B was the wife of A. Intestate's widow, or if there are more widows than one, all widows together shall take one share, right? So if let's say there were more than one wife, there were 3 wives, all of them will together take one share, right? Each widow will not take one share each, right? All of them combined will take one share, right? So intestate widow, in our case, this intestate widow will be B. Then rule 2 says that the surviving sons and daughters and the mother of the intestate shall each take one share. Surviving sons and daughters. In our question, the mother was not there in 2008. She already died, right? So we need not assign a share to her. Um, Surviving son was there, yes, C, and daughter D. She was married, but she was surviving, right? So in presence of surviving sons and daughters, we need not consider rule number 3 and 4, because rule number 3 and 4, they are the rules of representation. They represent the branch of predeceased son and daughters, right? So since in our question the sons and daughters, they were surviving, the son and the daughter, both of them were surviving. So we need not consider rule number 3 and 4. We can just apply rule 1 and 2 together. So applying rule 1 and 2 schedule 1, when when A died intestate in 2008, right? The property, it needs to be succeeded through 1956 clearly, right? The property that he owned, it was self-acquired, not ancestral. And when he died, he had class 1 heirs present. right? Wife, B, son, C, and daughter. All of them are class 1 heirs. So in presence of class 1 heirs, you need not move further, and all of the class 1 heirs, they will take the property simultaneously. And when we read section number 10 along with these uh, rules, then the wife has to be assigned one share, the son has to be assigned one share, and the daughter, she also will get one share. So there will be three parts of the A's house. That is the property in question, right? Three equal parts. So wife will also get one third, son will also get one third, and daughter one three each will be given to them. Now, interestingly, there is another factor in scenario one, and that fact is after 2 years of A's death, B, the wife of A, has also died, and she has made a will of her property in favor of the son C. Right? That every property of B will have to devolve upon C now. So this one third that she got from the property of her husband, this one third will also have to be added to the one third of the son. Right? So upon B's death, B bequeaths her share in the share of the property to C through a will. Now there is a case of testamentary succession. So in case of testamentary succession, we need not examine the provisions of HSA. It will go as per the intention of the testator, right? So the intention of the testator here is the property has to go to the son. The entire property has to go to the son. So whatever one third share she got from her husband's property, that one third now is to be added to the one third of uh, the share that she was getting, and now he will be having two-third of the ownership of the house, because one third will still be retained by the daughter, that is sister of C, right? So in scenario one, one third after the death of after the death of propositors, right? One third share will have to be given to everybody that were there from class one. Wife was there, mother was not there, right? The son was there and daughter was there. And since son and daughter were present, we need not apply the rule of representation. So one share each will have to be allotted to them. They will get 1/3 each. After the death of wife, this 1/3, which becomes the private property of the wife, right? This private property has to go through either again testamentary succession or intestate succession. In this case, we have a will. She has mentioned in that under that will that the property has to go to the son. So this one third now will have to be added to the son's share. So final outcome in scenario one, when the property was the private property of the male member, the senior male member, that is father of C, right? In that scenario, the final shares will look like this. C will C will get two-third, and the daughter of C will retain her one-third, right? But this was only first scenario. The second scenario is still left. Second scenario asks you that what will happen to the shares if B and not A was the original owner of the house. Now, till now, we were discussing the intestate succession when the property belonged to a male, right? That is A. What if now the property belonged to that the house belonged to B, not A? So B was a female. Now you will have to examine the provisions relating to females, right? Similarly, to males, private property of females will devolve either through the provisions mentioned in Hindu Succession Act in case of non-testamentary succession, and in case there is a will, then obviously these provisions are of no use. The property has to go through the will only, right? So here also I've made two sub scenarios, sub situations in scenario two. If there is again a case of non-testamentary succession, then sections 15 and 16 of Hindu Succession Act, they are to be analyzed, right? Section 15 and 16, they deal with the devolution of property in case of females, right? In case of females, it will be advisable if we first read section 16 and then move on to section 15. Section 16 tells you the order of succession and the manner of distribution, whereas section 15 again tells you the classes of heirs in case of females, the way we have seen under section 8 in case of males, right? In case of females, the classes of heirs are mentioned in section 15. So section 16 says, just who are mentioned in section subsection 1 of section 15. We'll see. Among the heirs specified in subsection of section 15, those in one entry shall be preferred to those in succeeding entry, and those included in the same entry shall take the property simultaneously. Now let's see what section 15 subsection 1 actually says. It classifies the like I said, it classifies the heirs in case of property belonging to females. Firstly, the property will devolve upon the sons, the daughters, and this includes children of predeceased son or predeceased daughter and the husband. These are mentioned as first classes of heirs, right? The first class comprises of husband and children includes also the children of predeceased son and daughter, right? These are class one, first category, which we should not use the word class one, right? First category of um, heirs in case of females. So rule 1 of section 16 says that that category wise, this first will be preferred over second, and second will be preferred over third, and so on and so forth. So you will have to exhaust first category first, then move on to the next one, right? So if anybody from the first category is present, the property will not develop on the other categories of heirs, right? So if son, daughter, husband, or any one of them is alive, then heirs of husband have no role to play, right? Then it also says that those included in the same entry, they shall take the property simultaneously. So if sons, daughters, and husband, all of them are present, right? Naturally, they have to, if we apply section 16, rule 1, they will have to take the property simultaneously, just like the way it was happening in case of class 1 heirs, right? And each category of class 2 heirs, they will take the property simultaneously. They will take the share in the property equally. So if sons, daughters, and husband they are present, they will take the property in equal shares. Now, in our case, what happened? The wife, in our case, the wife she died after her husband, right? So, as per section 15, husband was not there, but sons and daughters, the son and the daughter, they were alive. So the first category of heirs were present. So we need not consider other heirs of the female. First category, son and daughter, when we apply section 15 and section 16, rule number 1 together, right? Both of them will take equal shares in the house, that is 1 by 2 and 1 by 2, right? Here we need not assign any share to the husband because the husband has already died. She died later. She died in 2010, husband died in 2008. What if the case is of testamentary succession? What if the later facts, they remain the same, that before dying, she made a will, and she made a will in favor of the son, that is C. Then C will take the entire property, and nobody can raise his or her eyebrow, right? It is as simple as that. Now, with this, we come to an end of today's session, and I sincerely believe that it was of some help to you, and now you will be able to approach the problem based questions with much more confidence. And in case if you have any doubt, now I will take them. Let me just go through the comment section. Okay, I do not see any doubt, but Anirudh is again present today. Anirudh also attended previous session. Okay, Anirudh, did you like? Okay, thank you so much. We will be having more such sessions. Then with this, we can end this session. But before ending, I will just like to point out that if you really like this session, you must explore the comprehensive course that we have come up for judicial services examination preparation, wherein we will be dealing with these topics with much more details, and we'll be discussing equal same kinds of tricks and tips for you. You can make the most out of it. We'll be providing you with the exam specific modules, and we'll be giving you one on one attention. We'll be mentoring you at every step of your way. So please do explore that. And also, I would also like to make a request that you please subscribe to our channel so that you do not miss any information relating to any these kinds of sessions. And hopefully, I'll see you in the next session or in the classrooms. Thank you very much. Take care. But please remember, answer writing is all about practice, right? These tips that I gave you today, they will work. They will work that only when you practice them regularly. So I advise you to practice on your own. If you need us, we'll be there for you. Swatantra says it was a very good session. Thank you, Swatantra. And we intend to provide um, quality content to everybody. Thank you very much. Thank you.